The article from The Hill has sparked intense discussion as it outlines the legal argument that Congress has the power to block Donald Trump from taking office, but lawmakers must act quickly to do so. The authors, both former clerks for Supreme Court justices, present a compelling argument rooted in constitutional law, specifically the 14th Amendment. Their case hinges on the assertion that Donald Trump is an adjudicated insurrectionist, a designation supported by multiple legal and congressional actions. The authors begin by citing the Colorado courts, which after a full trial, found that Donald Trump engaged in insurrection. This finding was upheld by the Colorado Supreme Court, reinforcing the conclusion. Notably, when the case reached the U.S. Supreme Court, the justices did not overturn the factual or legal determination that Trump had engaged in insurrection. Instead, they sidestepped the issue, focusing instead on procedural and legislative requirements under the 14th Amendment. Section 3 of the 14th Amendment explicitly states that anyone who has taken an oath to support and defend the Constitution and subsequently engaged in insurrection is disqualified from holding federal, state, or local office unless Congress votes by a two-thirds majority to remove the disqualification. The Supreme Court, however, introduced an unexpected complication by suggesting that Congress must pass specific legislation to enforce this provision. This interpretation has drawn criticism for appearing to create an additional hurdle not explicitly required by the Constitution. Critics argue that the 14th Amendment's language is self-executing, meaning it does not require additional legislation to be enforceable. The provision is clear: those who engage in insurrection are disqualified. Yet, the Supreme Court's commentary, described as dicta or non-binding observations, implied otherwise, leading to concerns that the court has inserted unnecessary ambiguity into what should be a straightforward constitutional mandate. The article further bolsters its argument by highlighting Donald Trump's second impeachment, which was based on a single charge: incitement of insurrection. The House of Representatives passed this article of impeachment by a vote of 232 to 197. While the Senate did not reach the two-thirds threshold required for conviction, 57 senators, representing a bipartisan majority, voted to convict him. This outcome reinforces the claim that Trump engaged in insurrection, even if procedural hurdles prevented his removal. Adding to the evidence is the January 6th House Select Committee's investigation. The committee presented extensive evidence, much of it publicly available, demonstrating Trump's role in inciting and perpetuating the insurrection. While not a formal adjudication, the findings of the committee further support the argument that Trump meets the constitutional definition of an insurrectionist. Given this backdrop, the authors of the Hill article argue that Congress has the authority and obligation to enforce the 14th Amendment by refusing to certify electoral votes for Trump. The Electoral Count Act provides two grounds for objection during the certification process. First, if electors from a state were not lawfully certified, and second, if the votes were not regularly given. The authors contend that votes cast for a constitutionally disqualified candidate, such as Trump, fall under the latter category. This interpretation suggests that members of Congress can object to certifying Trump's electoral votes on constitutional grounds, bypassing the need for additional legislation. They emphasize that the Supreme Court's comments requiring congressional legislation are merely dicta, non-binding observations that lack legal force. Congress, therefore, retains the authority to act independently under the 14th Amendment. The practical and political challenges of this approach, however, cannot be ignored. Despite the constitutional and legal merits of the argument, there is skepticism about whether Congress will muster the political will to act. The current political landscape, marked by partisan polarization, makes it unlikely that a sufficient number of lawmakers would support disqualifying Trump. Nevertheless, the authors urge Congress to hold a vote to remove Trump's disqualification explicitly. Such a vote would force lawmakers to take a public stance, potentially influencing future legal battles and public opinion. If Congress fails to act, the matter could end up back in the Supreme Court, where the justices would face the issue directly rather than addressing it through dicta. Should the case return to the Supreme Court, the justices would be compelled to confront the constitutional language head-on. Critics of the court's earlier handling of the issue argue that the justices have repeatedly shown a willingness to favor Trump, citing cases involving obstruction of congressional proceedings and other constitutional disputes. This perceived bias raises concerns about whether the court would once again rule in Trump's favor, effectively overriding the 14th Amendment's intent. Despite these uncertainties, proponents of disqualifying Trump argue that Congress must act to uphold the Constitution and prevent an insurrectionist from taking office. They stress that failing to enforce the 14th Amendment undermines the rule of law and sets a dangerous precedent for future elections. The authors of the Hill article emphasize that this is not just a legal question but a moral and ethical one. Members of Congress must decide whether to honor their oath to the Constitution or capitulate to political expediency. They argue that the stakes are too high to ignore the plain text of the 14th Amendment, especially in light of Trump's actions and the evidence presented against him. If Congress chooses to block Trump's certification, the ensuing legal battle could redefine the boundaries of constitutional enforcement and congressional authority. Conversely, if lawmakers fail to act, it could signal a broader erosion of constitutional norms and accountability. In the end, the question remains whether Congress will rise to the occasion and enforce the Constitution or allow procedural ambiguity and political considerations to override constitutional mandates. The outcome will not only shape the 2025 presidential election but also set a precedent for how the nation addresses future threats to democracy.